We are now in public session. Firstly, before we get to the main item on today's agenda, minutes of the committee's meetings on the 18th of October and the 22nd of November 2022 have been circulated to members for consideration. Are they agreed? Consideration of the report of the Irish Penal Reform Trust on access to rights for people detained in secure forensic mental health facilities. The purpose of this meeting today is for the subcommittee to discuss the report of the Irish Penal Reform Trust on access to rights for people detained in secure forensic mental health facilities. To enable the subcommittee to consider this matter, I'm pleased to welcome from the Irish Penal Reform Trust, Ms Molly Joyce, Legal and Public Affairs Manager, Irish Penal Reform Trust. I'm also pleased to welcome virtually via Microsoft Teams from the University of Galway, Professor Eilionóir Flynn, Director of the Centre for Disability Law and Policy in the University of Galway, and Eilís. You're both very, and I think Eilís, you do research. So you're all very welcome. All those present in the committee room are asked to exercise personal responsibility to protect others, yourself and others, from the risk of contacting COVID-19. And I just have to read out a note on privilege. Witnesses are reminded of the long-standing parliamentary practice that you should not criticise or make charges against any person or entity by name or in such a way as to make him, her or it identifiable, or otherwise engage in speech that might be regarded as damaging to the good name of the person or entity. Therefore, if your statements are potentially defamatory in relation to an identifiable person or entity, you will be directed to discontinue your remarks. It's imperative that you comply with any such direction. Members are reminded of the long-standing parliamentary practice to the effect that they should not comment on, criticise or make charges against a person outside the Houses or an official either by name or in such a way as to make him or her identifiable. Parliamentary privilege is considered to apply to the utterances of members participating online in a committee meeting when their participation is from within the parliamentary precincts. There can be no assurances in relation to participation online from outside the parliamentary precincts, and members should be mindful of this when they're contributing. I would like to remind members of the constitutional requirements that members must be physically present within the confines of Leinster House complex in order to participate in public meetings. I will not permit a member to participate where they are not adhering to the constitutional requirement. Therefore, any member who attempts to participate from outside the precincts will be asked to leave the meeting. In this regard, I would ask any member partaking via MS Teams that prior to making their contribution to the meeting that you confirm that you're on the grounds of Leinster House campus. To commence our discussion, I will now invite Ms Joyce to make opening remarks on behalf of the Irish Penal Reform Trust, and I want to welcome you sincerely on behalf of the Oireachtas Committee. I want to thank you for being so generous with your time and your expertise, and the report is fascinating, absolutely, and we looked at it with great interest. So yeah, I'm really looking forward to hearing your opening statement today. Thanks very much, Molly.
Thank you very much, and I should say at the outset, thank you very much for the opportunity and the invitation to meet with the subcommittee today to discuss our recently published report entitled Access to Rights for People Detained in Secure Forensic Mental Health Facilities in Ireland. We are delighted that two of the report's authors, Professor Eilionóir Flynn and Eilís, are also available to participate in today's meeting. We will do our best to respond to any questions that the committee members may have following our brief opening remarks. By way of background, the Irish Penal Reform Trust is Ireland's leading NGO campaigning for rights in the penal system and the progressive reform of Irish penal policy. Our core message is that a penal system that protects and promotes human rights, equality and social justice and relies upon prison only as a measure of last resort will contribute to safer communities for everyone. In regards to the background to this report, in 2021 we commissioned the University of Galway Centre for Disability Law and Policy to carry out a scoping study to examine whether people currently detained in forensic mental health facilities in Ireland, namely the Central Mental Hospital or CMH, can access their rights. The research was funded by the Irish Human Rights and Equality Commission, and the report builds on the gaps identified in our 2020 Making Rights Real for People with Disabilities in Prison report, and I have a few copies of that report available if members would like them afterwards. It is important to note at the outset that this research was limited in scope. It involved a literature review mapping relevant Irish laws and policies, as well as small-scale qualitative research involving interviews with key stakeholders within the forensic mental health system. Such stakeholders included staff at the National Forensic Mental Health Service, advocates working in the area of disability rights, a lawyer and 2 organisations working in this area, making up a total of 10 interviewees. Regrettably, the limited scope of the project meant that interviews with individuals actually detained in the CMH was not possible on this occasion. The report ultimately aims to provide an overview of the issues arising around access to rights for people detained in the CMH, as well as an analysis of Ireland's rights obligations under the UN Convention on the Rights of Persons with Disabilities and other human rights instruments. And it was as much, I suppose, to say, an educational experience and knowledge-gathering experience for IPRT, as well as sharing that more widely. In terms of the findings of the report, what clearly emerges is that people with psychosocial disabilities who are currently detained in the CMH are not afforded their rights as enshrined in the CIPD and international human rights law. Examples of such rights breaches include, first, issues around the process by which a person may come to be detained in the CMH. So during the report, concerns were particularly raised as to the legal basis upon which people are detained, with the lawyer interviewed questioning whether there is any regular oversight of this. The report also notes concerns in respect of several of the pathways by which a person may come to be detained in the CMH. For example, it points out that there is no limit on the length of time that a person who is detained under a finding of unfitness to plead can be detained, and one staff member referred to a person in the CMH who appears to have been unfit to plead since the 1970s. The second area of findings was in regards to the breach of rights once a person and the daily life once a person is detained within the CMH. So concerns identified by the report included the fact that physical side effects of medications are not always fully explained to patients, the presence of a particularly paternalistic culture within the CMH as compared to community-based services, and the ongoing use of seclusion and restraint within the CMH, with that hospital using such tools at a higher rate than other approved centres and failing to use alternatives where possible. The report argues that the latter in particular breaches Articles 15, 16 and 17 of CIPD, which pertain to freedom from torture, freedom from violence and abuse, and the protection of the integrity of the person. The third area of findings was in respect of the review of detention and discharge from the CMH. So criticisms of the current structures and processes included the fact that there are no lay members or people with lived experience on the Mental Health Criminal Law Review Board, the minimum length of time, 6 months, that is required between reviews, and this was considered too long. Decision-making that is arguably paternalistic and or overly concerned with risk. The process by which a person may be returned to the CMH following a conditional discharge, which is decided by one individual, the CMH clinical director, although there is some oversight provided by the review board on that in those occasions. And the limited availability of placements and support within the community to which people can move on. Throughout the report, the overarching point is made that the UN Committee on the Rights of Persons with Disabilities is clear that disability-specific forms of deprivation of liberty contravene the Convention. Furthermore, while in Ireland we often do characterise our processes for referral to the CMH as a means of vindicating the rights of persons with disabilities, according to the Committee's interpretation of the Convention, these processes in fact amount to a violation of rights under CIPD. The report accordingly recommends, as Ireland's ultimate objective, the abolition of the current forensic mental health system. Now, we in IPRT obviously recognise that this is very challenging, and we are realistic that abolition of the current system is not going to happen overnight. The report therefore makes 17 more short-term recommendations that we hope would better align Ireland's current system with the CIPD and bring us closer to a system that is ultimately CIPD compliant. These 17 recommendations are set out at pages 62 to 67 of the report and include practical measures such as increasing transparency by requiring the CMH to publish annual statistics on the legal basis for detention of all patients, starting to offer mental health treatment outside the CMH for those unfit to plead and or found not guilty by reason of insanity, providing meaningful support to enable people to participate in the trial process rather than being deemed unfit to plead, ensuring access to independent advocacy within the CMH, mandating that all reported uses of seclusion and restraint include information on the alternatives attempted prior to the use of these practices, including people with lived experience on the Mental Health Criminal Law Review Board, and reviewing ongoing detention of individuals on a more frequent basis. It is hoped that these suggested reforms, alongside the other recommendations in the report, will help work towards the overarching goal of ending involuntary treatment and abolishing Ireland's separate tracks of detention for all people with disabilities, including those labelled with a mental disorder. It is also hoped that the report's recommendations may lessen the harms caused to people currently detained in our forensic mental health system. In conclusion, I want to just note and emphasise that this report was finalised before the publication of the final report of the high-level task force to consider the mental health and addiction challenges of those who come into contact with the criminal justice sector, and also before the opening of the new CMH in Patran earlier this month. IPRT welcomes both the high-level task force and the opening of the new CMH as progressive steps that will help address some of the current problems we see. In regards to the task force, we particularly welcome the various recommendations made to better divert people from the criminal justice system wherever possible. However, we are disappointed that the proposed measures were not really costed within that report. The opening of the new CMH in turn has addressed some of the concerns raised in this report around the physical infrastructure of the old building in Dundrum. In particular, we welcome the fact that certain design features of the new CMH will address issues around patients' open access to the bathroom at night time and better affords them privacy, which was a specific matter raised by interviewees for this report. What is clear, however, is that both reforms will need to be met with adequate resourcing to ensure the actions of the task force report can actually be implemented and that good practice can be maintained and progressed in the new CMH. It is also clear that while welcome, these steps alone will not be enough to address many of the issues identified in this report, and they will not in themselves create the broader cultural shift or paradigm shift towards CRPD recognition that is needed. Thank you again to the subcommittee for its invitation to attend today's session and its attention to these important issues, and I and my colleagues in Galway are also very happy to answer any questions arising. Thank you.
Thanks very much, Molly. Our first speaker today is Deputy Mark Ward from Sinn Féin.
Thank you, and thanks, Chair, and thanks for allowing me in first. Apologies to the witnesses. I won't be able to stay for the whole meeting, which I usually do in this meeting, the mental health meeting. I've somewhere else to go to after this as well. So, I just want to thank the IPRT and the University of Galway for carrying out this report. As you were saying, that the report highlights that individuals are being let down at each stage of being detained in the CMH, in the Central Mental Hospital. At the very start of the process, there are questions about the oversight of the legal reasons and why they are being detained, as well as the unfitness to plead, leading to one individual being detained in the Central Mental Hospital since 1970. So we're wondering how many others are in many other instances of this, of people being detained for decades. And if someone is deemed unfit to plead, I'm just wondering, to tease out what procedures or policies could be put in place to stop someone being detained for decades if they're unfit to plead, to make it more human rights compliant.
Absolutely.
Okay.
I can just take that and then I'll pass over to perhaps Professor Flynn, who I know will have further comments on that. In respect of what this report suggests, it's very clear that the current process of just deciding that someone is unfit to plead is not CRPD compliant, and that better, basically we'd be looking at decision-making supports for that person to actually enable them to engage with the usual criminal justice process and therefore access their due process rights. And I suppose, as the deputies rightly identified, it's really concerning to think that people who've been unconvicted of a crime, who've actually only been accused of a crime, could end up spending hugely long periods of time, and most likely longer than they would have spent in prison if they had just gone through the process and been convicted, that can be arising. And just to say, in terms of the numbers available, or the figures available to identify how long people might be there, there doesn't seem to be, as far as I'm aware, clear transparency around that, which is a real concern about actually knowing how many people in the CMH might be in this position. But I think in terms of the supports for decision making, Professor Flynn can probably elaborate on that in more detail.
Would you like to come in?
Yes, I'm happy to. Hopefully you can hear me okay. And again, thanks very much to the subcommittee for the invitation to present today, and also to IPRT for a great partnership in this research report. So I suppose what I would add to what Molly has said, of course, we don't have the data on the length of detention of individuals currently in the CMH, and that is something we've called for in the report as a first step. But in terms of what we could do differently with the unfitness to plead process, I think there's some really interesting pilot projects, for example, colleagues of ours in the Melbourne Institute for Social Equity have completed on how exactly you would do this. So, for example, in that project, they worked with a number of marginalised groups where people were disproportionately found unfit to stand trial, including Aboriginal people and Indigenous people in Australia, and they worked on alternatives to the current system that included support for the person to understand the trial proceedings, support for them to communicate with their lawyer so that they could give their lawyer instructions, so that they could understand what was happening in the courtroom. They had the opportunity to try out the space and see how it would work and experience it before they were actually required to be present for the trial. They had support in police stations during questioning. So there was kind of a long-term process of support that was put in place to really not start from the assumption that the person would never be able to participate in the trial, but actually to support the person to fully participate in a meaningful way, take part in the trial procedure. And this was found to be important for individuals not only because they deserve support to understand what is happening, and that is something that many different communities and groups could benefit from, not just disabled people, not just people who have a label or a diagnosis concerning their mental health, but in fact, many different people who come into contact with the criminal justice system would benefit from this kind of support and accessibility in understanding how the system works and being able to navigate it better.
Okay, thank you. Can I ask you a question, Professor Flynn, just in relation to the Assisted Decision-Making Capacity Act and Advanced Healthcare Directives, just in relation to the new act that went through the Shannon last week. How does this affect people who are detained under the Central Mental in the Central Mental Hospital, basically on a human rights basis? Has the Act improved their basic human rights, or has it not improved? Or just your thoughts on that. I'd be interested to hear what they are.
Yes, certainly. So I think one of the compromises, as of course Deputy Ward, that was made by Minister O'Gorman in the amendment of the Assisted Decision-Making Capacity Act was to extend some of the provisions around the applicability of advanced healthcare directives to some people involuntarily detained under the Mental Health Act. Now that's of course in the civil side, if you like, rather than the criminal detention side, which is what we're focusing on today. So there was never on the table from the Minister at all, as far as I understand, any question that some people detained in the Central Mental Hospital, for example, whether they're unfit to stand trial or whether they're not guilty by reason of insanity or whether indeed they've come there by transfer from a prison environment. There was never any willingness, I think, to extend legally binding advanced healthcare directives to that particular group. And again, while of course, understandably, a lot of the focus has been on people involuntarily detained under the Mental Health Act on the civil side, outside the criminal justice system, needing to have their advanced healthcare directives respected. That's really, really important, and we fully support that, and we're disappointed that that has not actually occurred in the amendments to the Act. But this community was even more marginalised. People detained in the Central Mental Hospital were never really part of the discussion at all about having a legally binding advanced healthcare directive. They are also excluded under the 2015 Assisted Decision-Making Capacity Act from having even if they make a perfectly valid advanced healthcare directive when they're well, setting out the wishes in terms of what treatments they would want to refuse if they were to subsequently lose capacity. Those directives will not be followed, will not be upheld, do not need to be respected under the law if they are then found to be not guilty by reason of insanity, or if they're found not fit to stand trial, or for some other reason they're transferred out of a prison environment into the Central Mental Hospital, because then they fall within the provisions of the Criminal Law Insanity Act, and those are excluded specifically from having legally binding advanced healthcare directives. So that is really concerning. We understand, I suppose, why there might be a lack of willingness to extend legal rights to this group on the one hand, but on the other hand, this is a really marginalised group of people who are already living in an extremely restrictive environment. And as we know, having some measure or control over one's treatment and decision-making about treatment is really critical for people's recovery. And that might also help to address some of these ongoing concerns we have about the length of time in which people might be spending in these settings. If people had more control and more choice in terms of their treatment options, then they might not need to be detained for such long periods of time in these settings. So for all those reasons, it's very concerning that there isn't more advancement in terms of what the Assisted Decision-Making Capacity Act can actually offer in terms of decision-making supports to people in these settings. Now, that is just specifically on the Advanced Healthcare Directive side. Obviously, there is nothing to prevent people from using the other support options under the Assisted Decision-Making Capacity Act, whether that's the decision-making assistant or co-decision maker, in terms of the support that they would like for making decisions in general, but in terms of their Advanced Healthcare Directive, it's important to acknowledge that that will not be legally binding for individuals detained in the Central Mental Hospital. And I know my colleague Eilís wants to come in on this as well.
Okay.
Actually, just on an earlier point, to just give deputies a sense of the number of people who we're talking about. At any one time, there's usually about 90 or so people detained in the Central Mental Hospital. And in last year, or 2020-21, there were 24 review hearings for people who were detained being found unfit to plead. Now, assuming that there was a review hearing every 6 months or so, that's probably about 12 people or so. But again, it's very unclear. There's no actual transparent data as to how many people are detained or the length of time people are detained. As I said, that one instance that we had of someone being detained for an extraordinarily long period of time got through the interview process that we engaged in. So, that's definitely one issue. And then I just wanted to echo the focus really at the moment is on this idea that people wouldn't be able to participate in a trial process. But, there is some great evidence that if you give people the support to engage with the trial process, then you're vindicating their rights in the sense that you're giving people the choice to engage. Like as it is at the moment, essentially people, if you're found unfit to plead, you're essentially denied the right to engage in the trial process whatsoever because it's determined that you can't understand what's happening. And so then you end up in this situation where, essentially you're almost in a limbo where you go to the Central Mental Hospital for extended periods of time.
Okay. Just on that just seems very, very odd to me. Like we live in a society where data is key, and I mean most of our policies are based on evidence, and that's the best way to do things. It's just I find it bizarre that no data is kept or is attainable on people who are detained in the Central Mental Health Hospital. Is there any reason for that? That's the first I've heard of that myself now. Is there any rationale behind that, or
I can jump in just on a general kind of data point and then pass over to the others in terms of the expertise of the CMH. I mean, it's a huge issue across the entire criminal justice sector. So I wasn't so surprised because, for example, we don't have any up-to-date figures on how many, the rate of disability within prisons, the rate of mental illness within prisons. I have, IPRT would often cite figures, but some of the figures we cite are from a study that was carried out by Professor Harry Kennedy back in 2005 in terms of the levels, and we're still using that. There are some more recent figures that we use.
Sorry to cut across you. Is that prisons in general, or is that the Central Mental Hospital, or is it right across the judiciary system?
I'm talking about prisons specifically.
Okay.
So in terms of actually even knowing how many people have, for example, an intellectual disability or are suffering from mental illness within prisons, very hard for us to actually know accurately. We know it's a big issue because we get a lot of communications about it, and it keeps being identified as an issue by all of the various monitoring bodies. But in terms of actual clear figures, it's very limited, basically, in terms of the actual research that's been done. And then I'm sure my colleagues can talk about the CMH specifically, the issues there.
Yeah, I suppose one of the issues could be in terms of the sensitivity of the, again, the potential for identifying, because this is a very small group of people, and sometimes people who are in CMH are in there as a result of very high-profile cases or very, very sensitive situations, very tragic circumstances, and so I suppose there needs to be obviously respect for the data protection rights of people detained in the CMH, but I don't think that would completely explain away why we don't know the breakdown, let's say, for those 60 to 90 people detained at any one time in terms of the legal grounds for their detention or the length of their detention. I don't think that would necessarily risk identifying anybody, and I think it should be possible to provide that. But it's not currently being provided, that's correct. So Eilís, I don't know if you wanted to add any possible explanation there.
No, and just to say that the figures that we do get come from the Mental Health Criminal Law Review Board. So it's even looking at the figures, as I said, it says there were 24 hearings, and then I can just look at that and assume that that's 2 hearings a year per person. But I can't say that for definite. The numbers, they're really concerned with how many hearings they have rather than the numbers of people that they're referring to. So even the data we have isn't I couldn't say for certain that there are 12 people, or there were 12 people detained. And again, maybe you were detained for a shorter period of time and you didn't get a review. Again, it's just very unclear.
Okay. Thanks, Chair. And I want to thank all the witnesses as well. Thanks so much for the report. Thank you.
Thanks, Mark. Our next speaker is Deputy Nessa Horrigan from the Green Party.
Thanks, Chair. I might just stick on that topic just for a moment, just for some clarity. So, and I presume the academics have some kind of sense that, is it that the data exists but not in a disaggregated manner that would be available to researchers or NGOs? So the data does exist, it's just not made available, or is it that we're not collecting? The reason I'm asking is because this comes up in Health Committee all the time. There's a big difference between having the data and not making it available, and simply not collecting the data. So do you have a sense of whether the data is being collected and is simply not available to us, or it's not being collected at all?
It's hard to identify what exactly is happening, to be honest.
Okay,
I think that obviously upon admission to CMH, there must be a record, right, of why the person is being admitted, on what basis. So a record must exist at some point in that process. But as far as we could make out during this, limited scoping review of the research, that's certainly not publicly available data or data that could be easily extracted from internal records. So the things that are made public are, as Eilís has already said, the number of review hearings, for example. That is publicly available data that's not disaggregated or broken down in the way that would be most useful to us to understand how many individuals it relates to. But the actual numbers and the grounds on which each of those numbers must exist at some level, but is certainly not being made publicly available.
Okay, so it sounds like the raw files are there, but it's not being collated in any way that makes it accessible.
Correct.
Okay.
Although, sorry, I just jump in and say that one of the lawyers who we interviewed did raise specific concerns, questioning whether that information is actually held. So with that proviso, and as well, there are some of the interviewees, as I said, that particular case of someone who'd been found who was unfit to plead since the 1970s, there was sort of a feeling that that perhaps that fact had kind of, I suppose, wasn't people. I don't want to say that they sort of found a person, but that seemed to be the sort of sense that people are detained and they're detained there for long periods of time historically, and that there was, I suppose, maybe a lack of clarity around why they were being detained.
Right, okay, so if we dig down into that, then that person was implying that the data was never collected to begin with. There's not a complete file around that person's pathway through the system.
Right, essentially, and I think for historic reasons, because if you're talking about people who are detained over long periods of time, the law did change. So currently at the moment, we're looking at the 2006 Criminal Law and Sanity Act, and I suppose it was sort of a legacy issue. And I suppose as well, because there are different pathways in, so most people who are in the CMH, it's to do with the Criminal Law and Sanity Act, so a finding of not guilty by reason of insanity or unfitness to plead. But there is a possibility of transfer under the 2001 Act as well. And I suppose that, and also a possibility that someone would be made a ward and then would remain in the CMH under wardship. So it was a lack of clarity as to which of those processes is actually the reason the person is there.
Okay, and so maybe that kind of brings me to recommendation 15 around review. So I'm hoping, I'm presuming that the example of somebody there from the 1970s is probably the worst case scenario or the longest that we're aware of. So let's, I suppose that maybe if somebody is there from the 1970s or 80s, I have a couple of questions around that. What would be the best practice in terms of timely reviews? What is actually happening on the ground? Who has access to those kind of reviews? And in a really, I guess, practical way, you know, if somebody is there in the long term, how many reviews, what's the cost of a review? So is it more costly to consistently review somebody, let's say every 6 months or every 3 months, than it is to formalise their detention in some other way, or remove them from the CMH and put them into a community setting. So there's a couple of questions there. I'm basically trying to understand how long-term detention would interact with a more workable review system.
I can just very briefly jump in. I mean, in terms of what the report obviously says more than 6 months, they say, in terms of the regular review, and points to the 2001 Act, which is a review, I think, after an initial period of 21 days, and that kind of disparity, I suppose, between that. I'll leave it to my colleagues in Galway to talk about best practice internationally in terms of what might be a better approach. But I suppose, and again, it's a slightly unique position for IPRT because, as I said, this was an information gathering for us. I guess from my perspective, what's really alarming and I think really stood out to me from this report was that we often are looking at the length of time people spend in prison, obviously, but that's very definite. And people know when they're going to get out most of the time, unless they're under a life sentence, of course. And even then, there's still a very clear process that they're going to follow. And what struck me from this is that it doesn't appear that there is any kind of clear pathway. Well, there is a pathway clearly that people are told that they need to work through in order to come out, and they have this review board. But this kind of ongoing continuous review, there's really no indication of, is it 4 years, is it 8 years, is it 12 years, is it 25 years? And that's really concerning. And just to flag one thing that one of the lawyers commented in this report, and it's something I know from my own background as a lawyer, is that often clients will actually say, I don't want to plead not guilty by reason of insanity, because they know they could actually end up spending a lot longer in the CMH than they could in prison. So it's a real concern. I think it's a very good question to be asked about what is a better approach to that. So I'll point to my colleagues who may have some international best practice examples.
Yeah, so again, I think we agree in terms of the length of review. 6 months is a long time to go without a review in this kind of setting, but even to increase the shorten the time period for the review would not maybe address some of the substantive and structural concerns that are leading to people spending long periods of time in the CMH overall. So one of the findings of our research was that people couldn't progress as they would wish along the pathway that would eventually lead to release, because the resources weren't there to support them to spend short periods of time in the community supervised, or to have temporary leave, because the supports weren't there outside of the CMH for them to do that, or there weren't sufficient resources within the CMH to support people to do those things that they needed to do. So people who had tried really hard and had followed all the steps in the pathway and had done everything they could do were still not able to access things like leave, because there wasn't the support on the other side. So I certainly can't tell you how much it costs to do the reviews, and that wasn't part of the research at this point. But I can tell you that what would certainly be needed would be more resourcing, or indeed a redistribution of existing resourcing, to ensure that there is greater opportunity for people currently in the system to leave it. Practical support for people to access community and to access support in the community to ensure that they don't return to the CMH again. So I think those are the pieces that are really missing. Even if we speed up the review process, we still need to address those structural concerns, because otherwise people are going to be reviewed more frequently but with the same outcome, because they can't progress to any other option. Eilís, I'm sure you might have more to say about the review process as well.
Yeah, I just wanted to echo all that what is the aim? Is the aim to sort of assist people, to get to a point where they can go back into the community, and then what are we doing to achieve that? I suppose just to point out that after we conducted our interviews, that individual in question, who'd been there since the 70s, was moved on to a different placement. So that is positive. And again, it's hard to tell how long people are in the CMH for, because again, it's not clear. But in the latest report from the Mental Health Criminal Law Review Board, they did notice they've done a 36th and a 37th review for someone. So again, assuming a review twice a year, that's about almost 20 years in the CMH. And again, I don't know on what basis that person is currently detained there. It's unclear, but and it's possible they were detained. Again, the review process that we're looking at here, the 2006 one, it's under the 2006 Act, so maybe they've been there even before that. So again, it's just really, that's just a really big concern that emerges, and it's not just Ireland with the CMH, it's across these forensic mental health detention facilities, and that's the point that the CRPD committee has made, is that essentially you will be detained significantly longer than you would be in a prison setting.
Can I ask,
emerges.
Can I ask two follow-up questions to that? One is, are you confident that every person there is receiving 2 reviews a year? Are you confident that that is happening? Or is it yearly, maybe in some cases? And how do care plans interact with that? What you're talking about there in terms of moving people into the community, making sure they have access in a kind of a phased manner, I presume, is what you're describing. How do care plans interact? Because we have dealt with that a lot in this committee in terms of how you resource care plans and how you ensure that people are involved in the creation of their own care plans, and how you ensure that other factors like capital spending, for example, don't interact negatively with them. So I presume that there's a natural tension in this scenario with you know, kind of penal law and care plans, and I'm wondering, could you speak a little bit about that?
Who would like to go first? Molly?
Sorry, I'll pass over to Eilionóir and to Eilís to
Sure.
answer.
Yeah, so again, I suppose the care planning process is very different in a context within when someone is engaged through the criminal justice process, right? So the level of control and choice that the individual has in terms of care plan is quite different in this context. And we can question that, and we can say that should not necessarily be the case, but the way that the legislation is set up, this is the way in which it operates. So patients in the CMH are supported in terms of their care through these 6 pillars of care that they have to progress through in order to access release or to ultimately be discharged. And so those are kind of predetermined. So, you know, the person can't opt out. Well, the person can, you know, the person can be I suppose, involuntarily subject to specific kinds of mental health treatment, as of course happens outside of the criminal justice setting as well, outside of the forensic setting. But here, I suppose there is a much greater degree of, I would say, clinical control, and so a much lesser degree of patient choice. At least that's what we heard in the interviews that we conducted with key stakeholders in the area. So our concern would be that this is, you know, there is an overarching concern with risk in a very different way when it comes to these forensic settings, and the way in which risk is evaluated is very different to what happens on the civil side, if you like, under the Mental Health Act. And this is really kind of all-encompassing in terms of what care the person is offered or receives or engages with. So the big concern is, what risk does this person pose to the community in a way that's different from how we consider risk under the Mental Health Act, although of course, you know, some of the same issues crop up there as well. So what we really argue in the research is that we need to think about risk differently if we're serious about compliance with human rights standards, and the way in which it has been so all-encompassing in terms of its level of control over individuals is not productive to recovery, is not productive to people actually being reintegrated into communities and having support to live good lives after spending time in the CMH. So we need to completely redesign all of that and move away from, like, ideally, of course, you know, according to what the UN Committee on the Rights of Persons with Disabilities is saying, we shouldn't have these separate forensic settings in which people can be detained for these periods of time, and with this level of coercion in terms of the treatment that they can be forced to accept, whether they wish to have that treatment or not. So those are the bigger structural issues, I think, when you think about care planning, that would really need a fundamental shift in order to meet Ireland's human rights standards under the UN Convention. But I'll come back to Eilís to see if you have more to add on the on the care planning side.
It was actually, I just had thoughts on the question about review and making sure people are getting them. So the legislation requires a review at least every 6 months. And people can request one before that, and the clinical director of the CMH can request one before that time period. And I suppose one thing that did emerge in our research is actually concerns around the degree to which people are involved in these review processes themselves. So there is legal aid for legal representation, but I suppose it was more the degree to which people's voices are heard as part of this process. And I suppose a concern that after a certain period of time, it almost becomes just something that gets done, and it's not really a process that's sort of engaged in wholeheartedly as a sort of a new process. And really looking at supporting people throughout that, not just from a legal, in terms of providing legal advice, but in making sure that people are real participants in the review of their detention.
Okay, thank you. Thanks, Chair.
Thanks very much, Nessa. Our next speaker is Deputy Jean O'Kenny from People Before Profit.
Thanks. Thanks, Molly, for coming in and the other guests. Just a number of questions. Probably mostly aimed at you, Molly. How do you define a forensic mental health facility? What's the definition of that? Because I've just never heard of being called forensic.
Yeah, well, I mean, my understanding, and my colleagues can come in in terms of the exact legal definition, but my understanding is it's essentially, I think of it nearly as meaning criminal. It means someone who's gotten caught up in the criminal justice system and is now in the mental health sphere. So there's a distinction made between the kind of mental health services of someone who has not apparently committed a crime, and then people who, because of their mental health, or because it's thought of because of their mental health, have committed a crime, and then we basically place them on a different track within the forensic mental health facility. And in terms of the terminology we've used for the report, we talk about forensic mental health facilities, but the only one is the Central Mental Hospital. It is the only designated centre under the legislation, but it is also an approved centre similar to other centres throughout the country. And I suppose the difference from my understanding is that obviously the Central Mental Hospital has that higher degree of security and control. So, as we've kind of said in the foreword to our report, it's not surprising that this report is quite challenging and quite complex, actually, because it's sitting at the direct intersection of two very complex systems, the penal system and the mental health system, which is essentially why we wanted to do this report, because we get asked a lot about mental health. And to date, we've really focused in our advocacy and in our kind of commentary around, the mental health the waiting list for people awaiting transfer from the prisons to the Central Mental Hospital. But we hadn't really engaged deeply with what actually happens in that next stage, even though that's actually part of the prisoner's journey. And if we're concerned with people in prison, then we should probably be concerned with the forensic journey as well.
Right. And what would be the definition of somebody that is deemed unfit to plead?
Well, I understand there's a legal definition, which I'm sure Eilís can come in terms of the exact legal definition, which is probably the best approach rather than me just giving it anecdotal evidence. Eilís?
Sure, yeah, and it's in the Criminal Law and Sanity Act, and it sets out a kind of a number of criteria. Essentially, it's where the court, so that's a judge or the person's solicitor or the prosecuting team, determine that the person can't understand the process due to a mental disorder, or isn't in a position where they can instruct their solicitor, or would essentially it's where the fair trial rights would not be vindicated for the person due to the fact that they just can't fully participate. But I do think it's important to note that it's not, in this situation, we're assuming that the person essentially has no agency almost, because it's not something you raise yourself, it's something that's raised by other people. And it means that essentially your degree to which you have a choice in this process is incredibly limited.
And I'm guessing in certain circumstances that the person that is in this situation has committed some pretty horrendous crimes.
Yes, I mean, I think sometimes that is the case. I suppose what I would just want to emphasise is that because of, I think, in particular, media reporting and coverage and what most of us would just hear day to day, we are very aware of the most serious crimes, but actually there are a lot of people who get caught up in this system, and it's for very, very minor offences. And that's perhaps, I mean, it's concerning for everyone, but it's perhaps even more concerning when you think about the fact that some of those individuals may end up in the CMH for very long periods of time, when the actual sentence that they would have received is, less than 12 months based on the law they've been convicted.
Right. So obviously the people that you're speaking about, say minor crimes, if it was a case they were in, say, Mountjoy or Wheatfield prison, they would maybe spend a small, short time. But if they're in the Central Mental Hospital, they will spend multiples of that.
Well, they could, yeah.
They could, on the basis, because they're on the judgment of the courts that they're not fit to plead.
Yes, exactly. And that's a really kind of, and again, it's this kind of slight lack of transparency. You can't point to figures or the numbers of people who are actually caught up in this. But, you know, there are examples, I mean, and this is a slightly different issue, but there were media reports, you know, about probably 18 months, 2 years ago, of an individual caught up in prison who was very unwell but was on remand and ended up spending such a long period on the waiting list for the CMH and actually was in prison longer than they would have been if they had just been processed and convicted of the crime that they were accused of. So that's a slightly different issue, but it's just, again, this kind of, there's all these kind of slightly strange things that can happen where someone can actually end up being detained for much longer than I think any of us would think is actually possible. I don't know if my colleagues want to come in and just on that point about the unfitness and the minor crimes.
Eilionóir,
Yeah, just to say, sorry, Eilionóir, just to say that this. As I said, there were 24 hearings in 2020-21. 7 of those related to people who were facing charges in the district court. So, you know, it is the other 17. It just says other courts. So again, unclear if it's the circuit court or if it's the Central Criminal Court. But yeah, just to point out that while we are talking about a range of crimes, ranging from, you know, up to the most serious, you know, there are people who are facing charges for what would be, it would be possible to plead as a misdemeanor in the district court, but then because of this fitness to plead regime, you end up with this scenario where the person essentially, because they're deemed not fit to plead, then they're deemed unable to decide to have it tried at the district court level, which is this sort of scenario where then it makes it, you know, it elevates it up to circuit court level, and it just, and we actually had a case. And it's cited in the report of that exact scenario. So this isn't like a hypothetical. So it just creates these odd legal scenarios.
Yeah, I was just going to mention that case as well, which I think where the person was being charged with theft, for example. So, like, again, not all of these are very serious crimes or like the most serious or, you know, violent crimes or anything like that, even though that might be who comes to mind when we talk about forensic settings. And certainly that's not the experience of everyone who is detained in that setting. So it's important for us to remember that too.
So there is situations where somebody has, you know, committed a relatively minor crime that could be in a facility such as this for years on end, because obviously their capacity is compromised in some ways, and the state feels that because they don't have capacity, they will be incarcerated indefinitely. There are cases of such as this.
That can happen, absolutely. I suppose the rationale or the justification for detaining people while they're unfit to stand trial is intended to treat them in order to make them fit to stand trial. So that is kind of the theory of what should be happening. But as we can see from the length of time that people might spend there and what stakeholders told us during the research for this project, that it may be a long time and people are still not being found fit to stand trial despite undergoing treatment and being in the CMH for long periods. So the goal of the system is intended to be to treat the person so that they can then stand trial. But again, the treatment is not always going to have that effect, and it may have other effects. And again, that's the problem. So the rationale for keeping them there is that we are going to provide this treatment, and once you've had this treatment, you're going to be in a better position to understand what's going on. You're going to be able to participate in the trial. But we don't even have data on how many people then are fit to stand trial, found to be fit to stand trial and go ahead into a trial process after being treated at the CMH. So we don't have that information.
Yeah. Just my final question is in relation to recovery. And that's probably, obviously if people are in this, institutions or facilities like this, obviously recovery and rehabilitation is key to the, I suppose, reform in relation to, and obviously there's a gravity of why people are, incarcerated in the first place. and that kind of I presume there's a full spectrum of that, from relatively minor crimes to crimes that would be very kind of the serious nature. So in terms of recovery, if somebody commits like the most serious crimes of our laws around murder and so forth, what's in terms of recovery? Because obviously if somebody commits a murder, they spend at least 10 to 15 years in prison, in jail, whatever. But obviously in situations where somebody is deemed unfit for trial, in circumstances like that, where first of all, where's the recovery kind of basis, and does that person then realise, look, they weren't of sound mind when they committed that crime. They are now. They're completely compos mentis, and where does that kind of I suppose paradigm end and begin in relation to that person that has may have not wasn't the sound of mind when they committed that crime, but now with doctors and so forth, they've deemed that person relatively fully recovered and of sound mind. I know everybody's different, but just yeah.
Well, I mean, again, my colleague may have more insight into the specifics on kind of the mental health. I think it's a really good question, very big question actually, and I do think some of the things that have come out from this report that have made me think is it kind of challenges how we think about punishment and what we're doing, because there is situations, I imagine, and it can arise where someone has perhaps committed a crime when they were not, by legal definitions of sound mind or whatever phraseology you want to use for that, and then even by the time that they get to their trial and maybe are found not guilty by reason of insanity, they are of sound mind. I'm using that term just as in terms of kind of how we might describe it in the law, and yet we still will end up in a situation where those people might end up being sent to the CMH even though they actually may have recovered. And I think there are examples within the report, and Eilís might be able to draw on those a bit more, of some people commenting on situations where someone may have been on bail on the offence, and then they go to court and then they're sent to the CMH, but they've been on bail and been completely fine for 2 years and been getting help and treatment in the community, and then they're sent to the CMH, and I suppose there's a bit of a question mark over, well, if they've already recovered, then why are they being sent to the CMH? And that's what I mean about the questions around punishment. It's actually, are we actually doing it because we have to do something if someone's committed a very serious crime and we can't possibly just let them out into the community? Well then, okay, fine, but that's actually something quite different than saying that we're doing it for their benefit and to treat them. So I think that's kind of a slightly a big question. And then I just wanted to say, in terms of recovery and rehabilitation, an issue that has come out, I think, in the report and that we would definitely be aware of is, and Ellen has pointed to it, is the lack of resources within the community for that kind of support. So, specifically you can talk about step-down facilities from the CMH. From my understanding, that is a big issue with the capacity to date. Now, the new CMH has a new intensive care rehabilitation unit with 30 spaces, which is welcome. And I know Eleanor may have slightly, that is still a coercive system, but it is a more welcome system from my perspective in terms of it would get people out of that very confined situation and back into the community. But again, that's only got 30 spaces. So that's welcome, but it's probably not going to address those capacity issues and actually provide the kind of support that's needed within the community to properly get people living freely within the community with those supports. And I think it's a bigger question, and what the report kind of points to as well is this idea that if we keep focusing on the institutional responses of prison and the CMH, we're never going to redistribute those resources to the community, which is where they actually could possibly be more effective. So it's quite a big thing to achieve, but I think that's kind of where the report is in terms of recommending where we go.
Yeah, just to add to that, I suppose the term recovery isn't used in the Criminal Law Insanity Act, so it doesn't really form part of the decision about whether someone is going to be released from the CMH. So, we might talk about that colloquially, and we might kind of have this understanding that people should be released if they're at the point in their recovery that would make sense. But that's not actually the legal standard that justifies whether they're going to be released or not. And as we've spoken about in this session, and as we've seen in the report as well, the view of the clinical director really is very critical to any release, including leave and other kinds of temporary release from the CMH. So it's not as straightforward as that person recovers and then they're released. That's certainly not the experience that we've seen through the stakeholders that we've interviewed from this research. But it does raise those broader questions as well about accountability and responsibility in terms of how we want to address the fact of what we do when people may come into contact with the criminal justice system at times when they may be in a mental health crisis or for other reasons related to their health or well-being. They're not in a great place in their own lives. And I suppose I do want to be clear, though, again, we're talking about people having, again, colloquially in this context, having committed crimes. If someone is deemed unfit to stand trial, there is no finding that they've committed a crime. Because by its very nature, they're unfit to stand trial. So therefore, they have been charged with a crime for sure, but they're never convicted of that crime. They're just found unfit to stand trial. So I think it's important to be clear, and accurate ourselves. So if that trial actually did proceed, perhaps the first person would be found not guilty. We don't know. But we need to be careful that we don't assume that finding of unfit to stand trial means that there is a finding that the person has committed a crime, because that's, legally speaking, that's not accurate. So it's just really important that we're clear on that. I don't know if Eilís, you wanted to add more in terms of the recovery or kind of what happens based on capacity.
Yeah, I was just kind of thinking about it kind of goes to the heart of the issue is in this idea around so people who are found not guilty by reason of insanity, that first bit there, not guilty, is this sort of recognition. This is what the law is doing, is to try and recognise that for due to a mental illness at the time, the person was not, I suppose, fully I suppose the law has determined that they shouldn't be held fully responsible. And that's due to the Criminal Law Insanity Act sets out they didn't know the nature or quality of the act, they didn't know what they were doing was wrong, or they couldn't stop themselves from doing it. And so I suppose the idea is that, it's what we're doing here isn't about punishment, I suppose. It's to do with essentially the reason why it's to do with, I suppose, helping people to recover in the sense that they wouldn't go on to commit further crimes, or that they would be in a position where they would be, able to live in the community with whatever support they need. So yeah, I just wanted to make that point.
Thank you both. Are you happy enough, Gino? Thanks very much.
Thank you very much.
Our next speaker is Senator Annie Hoey from the Labour Party.
Hi, thanks very much, everyone. Apologies, I'm zooming in here from the office, just between multiple places. Thank you so much for your presentation. It's been really interesting. It's uncovered a lot of things I wouldn't have really known about, even though I'm very interested around the topic of mental health being on this committee. I'm wondering if we could circle back. It was just I'm interested in around what you mentioned in the opening statement in the terms of the breach of rights once you're detained within the CMH. And just if you can elaborate a little bit more on that. And has there been any international or global analysis of this, or if you can, as to where we stand in comparison with other countries around this? Because I know there's differing ways that people are treated, and there's different systems and different methodologies. So I'm looking around the kind of international perspective on how we do things, and then a comparison, so a perspective on how we do things, and then a comparison in terms of, I'm not sure if we want to look at our nearest neighbours in the UK, and then my last question is there best examples? I know you further mentioned on that the ideal would be that we would not have this particular system. Is there an example, or is there a best practice globally of how we would achieve this, or kind of a pathway to do this, or are we kind of in a similar state kind of all around the place? Sorry, that was a number of questions there.
Do you want to come in,
Okay,
Molly?
yeah, I think I can come in on possibly the first one, just elaborating some of the rights concerns that were identified in the report, and then I think Eilionóir and Eilís will be able to come in on the international perspective and the best practice examples, which is a really good question. It's something we would kind of discuss a lot when we were preparing the report. In terms of some of the other daily life kind of findings within the report, so the report looked at access to healthcare, access to the community, access to advocacy, complaint systems, the seclusion and restraint issues, and also the gender implications of detention, and, you know, is there a difference there between how men and women are kind of treated within the system. So other issues identified around the kind of visiting system, you know, there was some good practice identified in terms of, you know, during COVID, there was expanded access to technology, which allowed people to have visits from families that may not have been able to visit as easily, and that recommendation 6 talks about providing, you know, expanding the use of technology, but also providing longer visits, because it noted that the length of visits has increased, I think, from 45 minutes to an hour and a half. But again, saying that this could go even further, you could possibly give people half a day, you know, for their family visits. In terms of the kind of leave, access to the community, you know, talking about leave not just being a thing that is only given to people who are on the pathway out of the CMH, which appears to be the situation at the moment, but actually trying to make sure that everyone's getting an opportunity to perhaps get access to leave, even, you know, on a temporary basis. In terms of then kind of the access to healthcare, the report looks in more detail at physical healthcare and mental healthcare, and kind of makes, you know, some recommendations around how that could be improved, particularly in regards consent to treatment for the mental health care. And a lot of the interviewees kind of really said, yes, people are involved in the mental health care decision making and they're asked about it, but some of the interviewees who are staff kind of questioned, well, yes, they're asked, but then how much do we really take that into account? You know, if the doctor disagrees, that kind of seems to be the overriding, you know, decision then. And then I mentioned the point about, you know, medication. Some of the advocacy organisations, I think it was, mentioned, you know, sometimes people not really being told about the impact of the physical side effects of medication, so that people actually can make an informed choice as to whether they want to take that medication or not. And then the seclusion and restraint I identified, but, you know, that is a really big issue. And I think actually just having had a look this morning at the Inspector of Mental Health Services report in the CMH, which is the most recent one, which was not published, I think, at the time of this report, there are some real concerns there about the lengths of time that people can actually end up spending on seclusion, and it seems to have increased again in 2021 since 2020, which is concerning given, of course, we still wait in COVID, and, you know, I don't think that's actually part of the reason, but I'm trying to kind of find if there's some reason why that would be, but it's concerning to say the least. And then I just want to say, before passing on to my colleagues, in terms of best practice examples, I mean, Eilionóir and Eilís should be able to expand. My understanding is there are some really good examples we can take from abroad, and we've tried to include those in the report wherever we can. But I think it is fair to say that this is a challenge for a lot of countries, and that probably no country has like managed to get a really best practice example. And I suppose it's a really difficult one, because you're talking about really a very fundamental shift in how we even think about this. As kind of said at the outset, we currently talk about all of this, and a lot of us understand, you know, a lot of us in the human rights sphere who are not experts in disability rights think of it as vindicating the rights of people. So it takes a big paradigm shift for us all to kind of think that actually perhaps that's not what we're doing at all, and that actually there's a much better way. And I suppose just one thing to say on that in terms of the better system, I do think that there is something in the points, you know, some of the recommendations that have been made here about, you know, diversion, or, well, some of the recommendations that have been made, for example, by the high-level task force around diversion of people with mental health and addiction issues. We would agree with that, but I can also see that that is not CRPD compliant. But I think it does tie into a bigger point that in the Irish Penal Reform Trust we try to promote, which is the idea that many people should be diverted, not just people with mental health, you know, illness or addictions, but that many people who are in prison probably shouldn't be there, and that there are other ways to respond. So I guess what I'm getting at is that the reform of this kind of forensic mental health system kind of goes hand in hand with the reform of our criminal justice system and how we think about crime and how we respond to crime, which is a very big thing to do. So that's why we've tried to break it down into more specific recommendations in this report. But I'll pass over to Eilís and Eilionóir in case they have more details.
Yeah, no, that's a great start. I think thanks, Molly, for setting out all of those issues. So yeah, I think, you know, we certainly, from an international perspective and a comparative perspective, the UN Committee on the Rights of Persons with Disabilities has been very clear on this point. And even though many countries are struggling to actually put into practice what the UN Committee has asked for, it is consistently asking for a dismantling of all coercive psychiatric treatment systems, including forensic ones, but also on the civil side. So from the perspective of the UN Committee, no one should be undergoing forced mental health treatment. Everyone who wants mental health treatment should absolutely have access to it, but nobody should be forced to accept a treatment that they don't consent to, because we don't force anyone to accept a physical treatment that they don't consent to. So we need to kind of achieve parity, and if we're serious about parity between physical and mental health care, that is what is required, and that would require a massive structural change in how our mental health laws operate and how the criminal justice system operates as well. So keeping that in mind and acknowledging the scale of the challenge, that is nonetheless the goal that we need to be working towards. And there are plenty of examples that we can draw on, particularly of, I suppose, tackling issues when they first emerge. So examples like not just restorative justice projects, but actually transformative justice, where communities come together to figure out collectively how they want to tackle issues of interpersonal violence or other issues that arise in communities because of, often this has arisen, communities create their own solutions because they are frustrated by the way in which law enforcement deals with these issues and the way in which it further marginalises, medicalises and creates more distress for people who are already in very difficult situations. So looking at examples of transformative justice work like Mia Mingus's project in California, which we mention in the research report, is a really positive one in terms of one that's been informed by, designed by disabled people, people with experience of emotional distress or mental health crisis, to think of a different way to respond when issues emerge that doesn't involve getting in contact with the criminal justice system in the beginning, and that would solve a lot of issues. So instead of, I suppose, if you like, it's an alternative way to look at things rather than diverting people out when they've already come in contact. If we could actually tackle the issues as they emerge and avoid that contact in the first place, that might give a much better experience for not just the person caught up in the centre of the situation, but everyone impacted by that situation as well, because people and families are often calling law enforcement or calling police where they have no alternative. They don't know what else to do in that situation. So if we create alternatives that actually work and that people have confidence in and can see working and can see having better outcomes, then people are going to use them. So that's what the international and comparative literature really shows us. But again, the UN Committee has made findings against other states, including Australia, for example, in a very famous case of an Indigenous man, Marlon Noble, who was detained in both a forensic setting and then eventually released into the community, but with conditions that were so restrictive on him that the UN Committee said that they continue to amount to a deprivation of his liberty in the community after he was released. Again, all because he was unfit to stand trial for a crime that he, again, never actually got to stand trial for, never actually got to clear his name on, that he maintained his innocence throughout, and that this was never something that he had been involved in, but he was accused and then got caught up in this entire system. So I think that we need to take seriously the mandate of the UN Committee and the challenge that they've set before all countries. We can learn from our colleagues, and in response in Australia, there have been a number of really interesting pilot projects working with people, including Indigenous people, who tend to get disproportionately caught up in the criminal justice system, and disproportionately also people with either a label of mental health diagnosis or might, fetal alcohol syndrome disorder, or different spectrum disorder rather, and different kind of labels that are attached to people, different experiences that people have, and trying to respond in those situations so that people don't end up coming into contact with the criminal justice system in the first place, I think is the best port of call for really restructuring our entire system, which of course is a huge challenge. Eilís, I don't know if you wanted to add more to that.
No, that's pretty much covered everything.
Okay, thanks. Annie, have you any more questions?
No, I'm okay for now. Okay. Thank you.
Thanks very much. And our next speaker is Senator Ashley Dolan from Fine Gael.
Thank you very much, Catherine, and I welcome Molly here as well. I know you're representing the Irish Penal Reform Trust, and I know that's about being progressive, I suppose, in terms of reform. Also to welcome Professor Eilionóir Flynn from the University of Galway, and I know Dr. Eilís as well. I know that the timing here is actually what I'm sort of curious about, because there seems to be a lot of activity in this space. I know that this report that you're reviewing here particularly is a review that analyses, I suppose, very certain areas. And I mean, you're looking to really ensure that the rights of people with disabilities are protected within the justice system here. I suppose I'm curious because I know that probably the timing, you refer to it, I think, in your own submission, that you've seen sort of some of the changes that have come through from the report that was issued in September, I know with Minister McEntee and Minister Donnelly, around sort of how people with sort of mental health issues and with addiction issues are managed, I suppose, in our prison service, and really how we should manage this. And I think that group, and I suppose I'd really like to ask maybe some of your feedback on that, because I know that the group, from what I understand, and that particular report, I mean, they engaged with staff, I think, the Department of Justice, the Department of Health, they had representatives from the HSE, they had the Central Mental Hospital, they had the Irish Prison Service, the Probation Service, they had An Garda Síochána, the Department of Children, Equality, Disability, Integration and Youth, they had the Judiciary, and the Department of Housing. So they had quite a wide range of people and groups coming together, and there's over, I believe there were 3 sort of subgroups on this, and there are over 60 recommendations that have been put forward, and a number of those are legislative as well. So I suppose it was really just to sort of see what your understanding is, because I know your studies probably, their studies started back in 2021, and this task force came together, the 3 subgroups, and then we've also had, you know, the €200 million investment in the sort of facility in Portrane with over 170 beds, and this again was moving that Central Mental Hospital from Dundrum into Portrane, and again that this is again just opened, you know, in September. I mean, they're looking at developing another few areas there as well. So there's been a lot of activity in this space, I think, from government side in the last while, but sort of the recommendations that are coming forward from this task force, they probably address some, obviously not all, of what you've put forward in your report, but I suppose if you might comment on some of the areas that you've seen that maybe that you sort of are seeing as progress in these areas in terms of what the task force has come up with in terms of recommendations. And I know really the groups that I was looking at were the subgroup, I think, on diversion is one of them. The second subgroup, I think, was on sort of capacity, which is really what that new hospital really was going to look at, just beds, which is something we always talk about here, is access to beds. And then finally, just the community issues and through care upon release from custody. One other comment I might have, again, is that we just went through the legislation here in the Shannon. I know with Senator in Cathaoirleach here, Francis Black, on assisted decision making and the decision support service there. And I suppose it really, when we went through and did our research on that, it really opened up to me the amount of people that would, at every stage of their life, may have challenges with mental health. And that can be because of us having an ageing population. At different times in our life, we may need assisted decision making, we may need the decision support service, we may be dealing with more people who are developing sort of neuro or cognitive challenges in older ages. And that, again, is just something that we have to be very conscious of. So I think that Assisted Decision Making Act and the Decision Support Service, maybe just some comments around that as well. So sorry, I suppose I'm asking you a couple of questions there, really about your opinion, maybe on comments on the recommendations, over 60 recommendations coming out of that task force. And then just on the new facility that's tackling, I suppose, bed capacity and maybe some of the other points that you had raised in the submission to us as well. And then finally, I suppose, is the assisted decision-making capacity, the brand new act that we've just seen come into place in the last week or two. And thank you for your contribution here as well.
Thank you. What I'll do is I'll maybe take some of those questions on behalf of IPRT, because I know that the Centre for we might have slightly different approaches to the high-level task force in particular. So I'll speak for IPRT. And first of all, I just want to address that point about timing, because it's a really keen observation in terms of there is a lot happening in this space at the moment, and in some ways it's a bit unfortunate the timing of how everything's worked out. So for example, this report, IPRT made submissions to both the Children's Committee and to this committee in respect of reform of both acts, and I think in both of our submissions we highlighted that we were doing this report but it wasn't ready yet, and it would have been great if we had done it a year earlier and then could have fed that in, but we are where we are, and I think there's a lot more attention being given to the issues, and that's probably why there's a lot happening simultaneously. So, there are some things that it would have been great for us to have this report this time last year, because we could have then fed in some of its findings, but we didn't have it, and certainly it's not knowledge, because as I said, it's not our area of expertise. It's not knowledge that we would have actually had to hand about some of the stuff that happens within the CMH, or some of the concerns that have been identified by this report. In terms of, though, the high-level task force and the CMH, the new opening, IPRT absolutely welcomes both of those. We called for the task force. It was one of our 5 recommendations in the programme for government, and so we were really pleased to see that progress and to see that progress kind of on the cross agency interdepartmental level, and to see that commitment from the ministers was really brilliant, and to see it published in a relatively short space of time, because we acknowledge it's a huge report, and as Senator, you've noted, it's absolutely, engaged with a huge range of actors across all of the systems, which is really a key part of trying to resolve some of the issues, because to date there's been these silos of people operating. So to see that kind of interagency interaction is brilliant. And in terms of the recommendations, we do, welcome many of the recommendations within the high-level task force. There are a lot, and so trying to kind of get our heads around each and every single one, has been challenging, I suppose, and we also need to see how they will kind of play out and interact with each other. Certainly, in terms of the diversion piece, that's a point that we would often have made, because in IPRT we get a lot of communications, and what we be getting told to us is this issue of people ending up in prison, and the worst case scenario, people ending up dying by suicide within the prison environment when they really just shouldn't have been there in the first place, and that's kind of our primary concern. So in terms of diversion, absolutely, but I think I always kind of have to, now having had this report, I'm now kind of more conscious that there is this kind of, you're still potentially diverting someone into a system that is actually coercive. So I think diversion, yes, but as I kind of said earlier, diversion of many people who could be, and I suppose the high-level task force is looking at mental illness, but also addiction, and many of the people who will end up there because of drugs, and certainly shouldn't be in prison. So we do welcome many of those. In terms of then the capacity issues, again, really good work was done by the task force, and I know it was led by, I think that was partly led by the Irish Prison Service, by a member from there, that subgroup, and some really good work around how to address that. But I think, it is being acknowledged, I think, by everyone that the new CMH, while it's absolutely welcome and it is, a much better facility than the old facility in Dundrum, it's not going to address the capacity issue in the long term. I think that's been fairly accepted. The capacity was in and around 102, 103. It's increasing to 170, but that includes the intensive care rehabilitation units and a CAMS service now as well. So it's not going to meet that issue. So we're still going to, IPRT has collected a lot of data over the past few years about the waiting lists within the prison service for people to get transferred to the CMH. It may be addressed to a certain extent, but it's not going to be addressed to.
I'd say probably what we need to see probably on a regional basis as well is just like where you can, when people are treated, that they're be able to move to other sort of types of maybe just step down or, like rehabilitative type services as well. And I think that's really something that I think has been highlighted maybe in that as well. But I would very much see that you have that sort of acute service there that's available within that 170 bed unit. And I suppose I would really like to see in a year's time maybe, and that's something maybe through our committee chair as well, maybe just seeing a review of how that new facility is up and going. Like obviously they've only just recently, I think it was opened, maybe even a month ago, roughly. So, maybe this time next year it would be really good for us to sort of get, maybe invite people from that the facility in for the hospital to come into us as well. But I suppose the capacity is something that, yes, has to be looked at, and particularly that's bringing together, as you said, it's the Departments of Justice and the Department of Health. And it's really this focus that we need to have. Like we have Minister Mary Butler, who is our minister, I suppose, in terms of mental health. But you're also here in this particular, like you said, it's bringing together justice and health and how we're able to support people who are, in a situation and need to be, I suppose that there is a vulnerability that is there, and it is about protecting those rights as well. And so sorry, I didn't mean to interrupt. I know you probably have other points to make.
Thank you so much, and absolutely, and I think it's been described before that the prison. I guess our concern is that what we are seeing, what we've been told a lot, is that the prisons are effectively being left to pick up all the pieces, and that's a quote that's been used before by people within the prison service of failings within the mental health community sphere, that people get to a point where they then end up in prison. And I think it goes back to that point that Eilionóir said, the best approach would be early intervention, so someone never even comes to the point of interacting with the criminal justice system in the first place. But I just also want to...
Can I ask your opinion then on the decision support, how is that, say, for example, if someone does not have the capacity to be making decisions, how potentially could there support people or the people who would be able to make decisions on their behalf? How, or what are your opinions on that particular act and legislation?
Well, I'll pass, I'm not an expert in the decision support or assisted decision making, so I will pass over to my colleagues, but what we have said from our position is that we are just very clear about just trying to remind people that the assisted decision making will apply to people within prisons as well, and not to forget that cohort of individuals. And just one point before I pass over to Eilionóir and my colleagues just to talk about a bit more about that, is just the acute need absolutely in terms of transferring people out, but I just want to highlight the lack of resources within the prison system to help people get the mental health support that they need. So actually, if you had better supports within the prison system, you may not have as many people hopefully needing to, or being deemed as necessary to be moved out of the prison system. And what I would just point to in that regard is, we've seen an IPRT that, a 2015 report recommended that there be one psychologist to 150 prisoners, and we've never gotten anywhere close to that. This time last year, the figure was in and around 1 to 257 beds.
Within your research, I suppose that might be a question here for the researchers involved as well, like were there psychiatrists involved? Because I know you've highlighted that your report has been limited in scope. It was a literature review, and then you engaged with, I think, a number of staff. I suppose I was curious as well about the type of staff. Were they medical staff? Were they prisoner staff? And then also, were there psychiatrists also involved in your study?
Yeah, I can actually pass it over to my colleagues on that, and perhaps come back in if there's anything else to pick up on.
And just, I suppose, just any feedback as well, say in the adult caution scheme, I know that's been recommended here as well as one of the elements, just about under the diversion, sort of, like how do we make sure that we're trying to, that people are not ending up in the prison service going forward, what are people's opinions on that element as well? Thank you very much, and thank you, Professor Flynn, as well.
Thank you. So just to start with the task force again, as Molly's already alluded to, we would have a slightly different position to IPRT on that in terms of the task force recommendations. There are some, of course, that we think have a lot of potential. So, for example, the recommendation that research be commissioned to establish the extent of persons with mental health difficulties appearing before the courts and the broader needs of that cohort in terms of accommodation and so on. We completely support that, and we think that is absolutely necessary. There's another recommendation around the creation of assertive outreach teams to make mental health care and housing supports available to people and people in distress, and particularly to ensure that people don't enter the criminal justice system in the first place. So as we've been talking about, we completely support that, as well as long as it's, of course, with the person's informed consent that they, with their decision about whether they access those services or not that are offered to them in terms of outreach. Our concerns then in terms of our human rights obligations and how they relate to the findings and recommendations of the high-level task force, we would see, and we can see international evidence, and we can see the UN Committee's position on this very clearly as well, that systems of diversion based on impairment, based on diagnosis related to mental health, are themselves inherently problematic in terms of the human rights obligations under the UN Convention on the Rights of Persons with Disabilities. So a fundamental transformation of the criminal justice system is certainly welcome to ensure that many people caught up in that system who shouldn't be there aren't there, but separating people out on the basis of a diagnosis is inherently discriminatory on the basis of disability according to the UN Committee on the Rights of Persons with Disabilities, and I think we really need to acknowledge that. So that is certainly an issue when it comes to the high-level task force findings. Another issue we would be concerned about, again, based on our obligations under the UN Convention on the Rights of Persons with Disabilities, would be the recommendation from the task force of consideration of community treatment orders. So again, this is a practice that has been heavily criticised by the UN Committee as imposing a kind of deprivation of liberty in the community on people. And we've talked about community support as being vital for recovery. Again, part and parcel of that fundamentally must be that the person wants to engage in that. Otherwise, it's not actually going to have the same effect. It's not going to be valuable. It's not going to be meaningful for the person. It's just another form of coercion that's being imposed on them. So again, while we understand the impetus to try to keep as many people out of the criminal justice system as possible, we think that those ideas are actually quite problematic in terms of Ireland's human rights obligations. So we would certainly query some of those recommendations, and we would like to see greater scrutiny of the recommendations in terms of Ireland's obligations under the UN Convention on the Rights of Persons with Disabilities.
Professor Flynn, can I just ask then, just in relation to your studies, was there a psychiatrist involved in the report that you put together?
So we have to be very careful because we only interviewed a very small group of people, and we have to be very careful. Everyone participated on the grounds of confidentiality, and since it was only the Central Mental Hospital in terms of the staffing, because that's the only designated forensic setting, where we agreed with our participants that we would not reveal their disciplinary background. So I'm afraid I can't give you a straightforward answer to that question.
Okay. So I know that I suppose you've indicated that there's further research, but how are you looking at further research following on from what's come out of the task force? They have now, I think, roughly 60 recommendations. I know in your report here there's roughly around 17 recommendations. I mean, how do you propose to engage in? You've mentioned further research, but I suppose I'd be curious to sort of see how the groups might work together to feed into each other, and particularly I suppose when I just see that the wide breadth of groups that have come together around the task force report, there seems to be quite a lot of different agencies and groups that have fed into that, societal as well.
And that's very valuable. So I'm actually referring to recommendation 3.6 of the task force, which was a recommendation for further research of the task force that the task force itself made. So I think that is a recommendation that we would be very anxious to see carried out in a way that kind of, brings together some of these core concerns that we identified in our research as well. So we would see that as an area for potential future collaboration, absolutely.
Okay, so all right, that's really positive.
Sorry, do you
ahead.
want to come in there, Eilís, as well? Are you okay? Is there anything you want to follow
maybe just to mention that it is actually really interesting that under the fitness to plead section in the high-level task force report, they do refer to assisted decision-making and possible law reforms to integrate assisted decision-making into the fitness to be tried process. So that is definitely positive, and it would be great to see further development of that recommendation. That was just one extra thing to add in.
Yeah, very good. Sorry, I don't know, I'm trying to, I don't know, was there any other points actually that we wanted to go through, but I suppose
Sorry,
if you have
do you
anything
want
else to add. Yeah.
Just to say, we do, I'm just looking at the recommendations around the adult caution scheme from the high-level task force, and I think we would support those, and in particular, the extension of the adult caution scheme to cover simple possession of other drugs, and which could have the benefit of, preventing a person in crisis, preventing the criminal justice system. So we would agree with that. I think also there is some welcome language within the task force around some of these, in respect of the adult caution scheme, but also addiction and mental health awareness training and Garda Síochána, talking about evidence of crisis, mental illness, addiction, or situational trauma. And they also talk about, training the guides in relation to diversionary approaches in appropriate cases with regard to mental health, addiction, homelessness, lack of maturity, or other circumstances. So it's just, there is some language there that I think is good that we can kind of draw on in terms of expanding that approach, that it's not just about someone with a mental illness necessarily, but someone who, is young or is homeless, or there might be situational reasons why they're acting the way they are, and perhaps having a more empathetic approach to that doesn't result in that person ending up in a police cell and then in prison.
Okay, so that's really positive. I don't know if there's any other final comments. Thank you, Chair. That was just, I suppose, the fact that all of it came together probably in the last 6 months or so. There seems to just have been a lot of activity here, and I think it probably maybe is a case of trying to look at what's come out of the task force, what you've been reviewing here in terms of your research, and I know that you've spoken about the further research element there, and I suppose what I would be very curious about is just how the new hospital, giving it a number of months to get up and going properly, that we would, as a committee, I suppose, be able to look at maybe just the outcomes from that. And I think what I saw as well, really out of the task force, is sort of they've given the short-term, medium-term, and sort of long-term forecast against a number of those recommendations, and I'm assuming that a number of those will have to be prioritised, within sort of the capacity of each of the departments of justice and of health as well. And public health, I think, is very important. And to me, and to my mind, there are so many different areas that come together in this, because it is the community health, it is our sláinte care, it is sort of our pilot programs that we have around addictions, and so many other supports. Like, for example, in Banaslow, if you have a mental health, if you have a primary diagnosis of mental health, then you can get support for addiction. But if you don't, then, you know, that may not be available in the local area. And there's also very much a lack of access for those types of supports for people with mental health difficulties. And I think that I would hope the Irish penal reform would be looking at sort of those elements within the community as well, because that, to some extent, your GP is your very first port of call for families dealing with people with mental health challenges. And how do we support our GPs in rural areas, and how do we support networks in rural areas to I suppose, deliver care at an early intervention stage? So that's, I think, crucial, and working with our guards around that too.
Thanks very much.
I might just very quickly thank you very much, and absolutely that's something that IPRT will kind of continue supporting and collaborating with others as well with expertise in mental health to kind of support on. Just two quick things in respect of, you know, something that the subcommittee might also, in terms of, you know, looking at the CMH, I think that's a great idea to see how it's operating in the future, but also just in the high level task force, the resourcing point again. It's great to see the kind of timing of these recommendations, the short term, the medium, the long, but there wasn't really any information given about the resourcing, and it was actually released, the report, in and around the same time as budget 2023, so that was a bit concerning, because you do want to see, well, if the resources aren't put into this, then it's not going to, a lot of these things will not happen, but well, also the monitoring. So I think there are plans in place for cross-departmental monitoring, is my understanding, but I think that's something that we certainly will just be kind of trying to keep on top of now. Who is monitoring it? And who's actually keeping an eye on these things being implemented?
I do think from Minister Helen McEntee's perspective, you know, she has dedicated a lot of, you know, interest in this, and I suppose the fact that that hospital, like that €200 million investment, I mean, that's the largest investment from what I understand outside of the acute hospital sector, and we're so in dire need of beds in the mental health area as well. So I would just sort of see that there is joined up thinking at government level between Department of Health and Department of Justice on this to date. And yes, we would like to see that to continue going forward as well. Big time. Thank you.
Thanks, Aisling. Do you want to come in, Eilionóir or Eilís, on any of the questions? Have you any other more comments to make before I ask my questions?
One more, if you don't mind, just in terms of, again, I think it's really valuable to see interagency cooperation in the task force and in other processes to try to resolve some of these really fundamental structural barriers in how our criminal justice and mental health services are currently operating. But the one thing that I would encourage us to do more of in future processes, including in the resourcing and prioritisation and implementation and monitoring of the task force recommendations, would be to ensure that we are actually listening to the voices of people who have experienced that system firsthand, and particularly people who themselves have been given various mental health labels, not to undermine the views of families and how, but families may have a different perspective on what happened to the person than the person has, having actually lived through that system themselves. And I think that, of course, there were, you know, opportunities for people to be consulted in that process, and they were, but in terms of having an equal seat at the table and equal partnership, we're still a long way away from that in most of our processes. And I think we need to, you know, continue to strive to achieve that in all the future implementation of the planned reforms that are ongoing within the criminal justice and mental health services. So it would be remiss of me if I didn't mention that particular importance of the lived experience voice, and it being actually central to decision making, because I think that is still an area we need to make a lot more progress on.
Thanks. And Eilís, do you want to come in there at any point? Are you okay? Is there anything you want to comment on? No.
No, okay. All good, thank you.
No problem. Thanks very much, Aisling. I have a couple of questions myself that I have to ask. But firstly, I just want to say thank you so much for your work on this. I mean, it's just phenomenal, the work that you're doing on human rights and being the voice for those who, you know, it's quite moving actually that you're being the voice for those who don't have a voice. So I want to thank you sincerely for that. My first question is, it's around legal aid, and I just wanted to ask, what legal aid are CMH residents entitled to? You know, how does it compare with people in prison who can avail of the custody issue scheme?
I will pass over to my colleagues. I think they'll probably know more about the specifics of this. I know legal aid is available, obviously, for people, and there's a scheme available for people to get legal representation before their appearance before the review board. And I guess I'll pass over to my colleagues, as I said, because they will know more detail on this. But just to flag that IPRT is very keenly following the review of civil legal aid, the consultation that's just been opened, and that former Chief Justice is sitting on the board of that, and the deadline's just been extended till February. So we will actually be kind of getting our head into this, because it is an issue for people in prison, just to address what gaps there might exist, specifically for civil legal aid, but also I think arising out of this report, addressing what gaps there might arise. So I think that's kind of an area of future work. So I'm very happy to keep the subcommittee updated on that and pass on our submission when we complete it. But my colleagues might have more detail for the moment on the legal aid provision available.
Eleanor or Ashley?
I think Eilís might be better placed to answer this one, actually.
Yeah, sure. So it is a legal requirement that you would have a legal representative, provided for, legal aid provided for that at your review board hearing. And so the Criminal Law Review Board has put together a panel. I think there are about maybe 20 or so solicitors on that panel, and that people can avail of legal aid to have a legal representative at their review board hearing.
Thank you. And then we hear a lot about staffing issues. I suppose this is something that I just wanted to touch on. And we hear, in the Health Committee and the Mental Health Subcommittee. I just wondering, do you have any sense of staffing levels in CMH, and do you think that they're adequate?
So certainly my understanding is that there are some issues around staffing, particularly in the CMH, and that there are potentially kind of ongoing issues, and that's kind of tied into some of the issues around the delays in transfer to the new building. I think my colleagues will have more detail on the specific issues, but I guess I just want to also flag, the mental health the staffing of mental health positions within the prison service is also an issue. Yeah. I think it's an ongoing issue for kind of staffing. Now, the Irish Prison Service has been doing a psychology recruitment. I think they've hired 8 people since May who are hopefully going to start in 2023, 8 psychologists, I think of different levels. And they say that they are also, my understanding is, going to run a new campaign for psychologists in May, June of next year. So there are attempts to address that, but I know that there's been issues with them recruiting and then retaining healthcare staff across all the kind of areas of healthcare, and as I said earlier, that ties into the kind of problems with then the availability of mental health care support within the prison service. And I guess one other issue I know, just from having spoken to people, there are issues around the staffing levels of the prison in-reach and court liaison service, which is really only operating in Dublin at the moment, as far as I understand it, and that's part of the National Forensic Mental Health Service, the staff, but they work within the prisons, and the staffing levels, my understanding is, I suppose it is a very difficult job, so retention can be quite difficult as well, in terms of keeping people with sufficient experience and expertise to kind of work in that area. And there are recommendations within the high-level task force to roll out the prison in-reach and court liaison service, but if that's going to happen, they're going to need a lot more staff to do it, and qualified, experienced staff to do it, because I think my understanding is it's not something that you would have someone necessarily very junior, very new, starting in on. I mean, obviously people can be trained up, but you need that kind of level of expertise as well.
Yeah. Eleanor, do you want to come in?
Yeah, so just from our perspective, again, in terms of the staffing, so the staffing within the CMH is obviously very directed towards, providing the care within that setting. So where we were really identifying the need for more resourcing in terms of staff and other kinds of support was to get people out into the community. So whether on, supervised access or leave, short periods of leave, and then ultimately on discharge. So we would really see the need for staffing and resources to be directed there, and also to offer people, greater choice in terms of what activities that they might want to complete while they're in the CMH. So again, a lot was focused on the provision of, physical and mental health care treatment specifically, but in terms of other things that people would, in terms of people's access to education or other, pathways that people might want to, improve their employability while they're in the CMH, with a view to reintegration. Afterwards, these options were often under-resourced comparatively. So these are the areas where we would really see a need for greater staffing. I don't know, Eilís, if you want to add more to that in terms of what specific stakeholders identified as the gaps.
No, I suppose just maybe the point, and I don't know if we really discussed it before, but around advocacy. And so at the moment, the way it operates is it's the advocacy organisation are staff of the Central Mental Hospital. And there were just some concerns raised about that in the report in terms of independence of the advocacy. And I suppose just the importance of advocacy in this setting for people. So to make sure that, you know, because if you're living in this setting day by day, the things that matter to you, you know, the voice of having that advocacy support to, you know, make sure that the place it's really important for people. And you know, that was just one thing that emerged, was possibly a greater focus on independent advocacy services.
Thanks very much. And then I have a couple of more questions that I just want to run by you. What role do you think OPCAT ratification could play in the oversight of CMH?
Yeah, I can absolutely come in on that. IPRT has been quite involved in looking at the new general scheme of inspection of places of detention bill. Obviously, we've been focused a lot on the justice sector and the new inspectorate of places of detention. But my understanding is that it hasn't been put into the legislation in terms of who exactly, which organisation will be designated as the national preventative mechanism for the mental health sphere or for institutions such as the CMH. But my expectation, or our expectation, will be that it will likely be the Mental Health Commission and the Inspector of Mental Health Services, because clearly they already have a role inspecting the Central Mental Hospital, so it would be a natural fit. And I you know, reading the legislation, that seems to be the kind of intention of what will happen. I suppose what our view is, and this is for all sectors, is that it's really important that there's an understanding of OPCAT and what it's about, and that it's about the preventative function. It's about trying to prevent torture from happening. It's not a complaints or an investigation body. And if we are going to designate existing bodies as the new NPM, such as the Inspector of Mental Health Services, there will need to be a very clear delineation between their different functions, and perhaps better resourcing, or again delineation of resourcing, so that they have the NPM function under OPCAT, and then all of the other functions that currently exist. And that is our position, I suppose, based on the approach that it looks like it's going to be taken. Of course, there are other ways that it could be done. You could set up a brand new national preventive mechanism for Ireland. But my understanding is that's not the approach that's going to be taken. So in those circumstances, we're very clear that, you know, as it stands, we can see the logic in, you know, keeping that kind of inspection, with that kind of monitoring with the existing body that has expertise in the area, but there needs to be a lot of kind of work done, I think, and this is across all sectors, just around understanding OPCAT and what it's going to mean and what the actual function of it is and how that differs from perhaps existing functions.
Great, okay. Ellen or Eilís, you okay to move on?
Yeah, I just want to add one thing there on the OPCAT, because again, I think that's you know, I appreciate this is probably not the approach that is planned to be taken, but again, that could be a crucial role for giving a really, you know, important part in the decision making and in that monitoring process to people with lived experience of these systems again. And that's not necessarily foreseen, but it has. We have, you know, we have international best practice that shows how that has been done quite successfully in other jurisdictions, including monitoring these kinds of places of detention like forensic settings, but also monitoring settings that, let's say, would be monitored by HIQA, like residential settings for disabled people, which could also come within the remit of OPCAT. And again, the involvement of disabled people in the monitoring process themselves could be really valuable in terms of getting an insight into what the applicable human rights standards should be and whether or not they're in fact being met in those settings. So I think that could be really essential. We've seen, for example, recently, just a few months ago, problem in implementing OPCAT in forensic settings in Australia. So we want to make sure that we are not going to set ourselves up for some of the same mistakes that other jurisdictions have made, and we need to make sure that all of the legislation is in place in order to make sure that there will be full access to all of the settings that should be monitored by OPCAT by the National Preventative Mechanism.
Thank you. Eilís, you don't want to come in there, do you? You okay? Okay. So I just wanted to ask, can you give us an outline on the additional research you'd like to see conducted in this area?
Yes, absolutely. So I think as a starting point, and it's recommendation 2.2 actually of the high-level task force, further research on the prevalence and impact of mental health conditions and addiction across the prison estate. For IPRT, I think I said at the very outset, you know, we don't even have up to date data on the rates of addiction and mental health needs within the prison estate. So that would be a really useful starting point. I think some of the broader things that Eilionóir already flagged as well in terms of broader research around the mental health and addiction side is in subgroup 3, so Alan can pick up on it, but in terms of the mental health needs across the forensic system as well. In terms of then additional research that was identified by this report, as I said earlier, there was some identification of the issue around gender and the treatment of female patients within the CMH, and particularly concerns that there was no kind of stratification, that the male patients are stratified based on, according to their needs, I suppose, but that doesn't happen for female because there's so few of them, I suppose, and they're all in one unit together. And that may be addressed to a certain extent by the new CMH because they're getting more female spaces, but equally it creates a potential concern that the more spaces you create, the more you are likely to fill them. So we may end up just seeing more women being detained in the CMH. And I think in terms of that gender, what the report says is, this is a potential issue, but that there definitely is room to do some further research around whether there are particular issues for gender minorities, I suppose, within the CMH and forensic mental health settings. And I guess I would just flag in that regard, certainly for IPRT, we focus a lot on women in prison as well. And there are certainly some indications that there are particular needs there in terms of addiction, with higher addiction needs and potentially higher levels of experienced trauma and physical and sexual abuse of the women who end up in the prison system. And so certainly from that, there may be scope for trying to look further into the forensic mental health system. And I don't think, as far as I'm aware, that that's really ever been done. And then I guess I just want to say in terms of further research, kind of, for us, as I said, this was a scoping study. It was a small-scale research funded by IREC. And part of what we were trying to do with this was also just identify the gaps that potentially patients within the National Forensic Mental Health System fall within, in that as well, in terms of the advocacy organisations. You have IPRT, for example, working on behalf of people in prison. You have organisations such as Mental Health Reform and others working on behalf of people with mental health needs. But I don't know of anyone specifically looking at this particular cohort, and that's kind of why we did the research. So the scoping study is great in that it identifies it, but I think there's probably further work to be done around, does someone or some organisation need to be actually taking a handle and saying, this is what we do now? Obviously, that's for every organisation to decide for themselves. But I suppose there's kind of further research there around, this is very much just initially identifying some of the concerns, and there's further work to be done now between, ourselves and others in the sector to identify how we might best address some of those needs with our colleagues, in academia as well, and our colleagues across all kind of key decision-making bodies.
Mm-hmm. Thank you. Eilionóir, do you want to come in there?
Yeah, just to reiterate again, all of those areas that Molly has identified for further research are really important, so we would definitely support all of that, but especially to research the actual, again, I know I sound like a broken record, but the lived experience of people in the CMH or who have spend time there would be really, really valuable because we weren't, in the short time frame of this research, able to include them in the research. And I think, it'll certainly be challenging to access that population, but that research is really, really needed to understand the full spectrum of the experiences. So we're, gathering this from outside stakeholders and stakeholders who work within the setting. That's not the same as the issues that are identified by people living in the setting might be very different to what we've identified so far in this research. So that's certainly an area. And again, I think that people who've experienced the system are best placed to really come up with the solutions that would avoid others having to go through what they've gone through. And I think we really need to put that front and centre of further research into this area, because that's a voice and a perspective that has been missing so far.
Thank you. And then just my final question. And a few times you've mentioned resources or possibly redistribution of the existing resources. I'm wondering, if you had a magic wand, I suppose, what would be, what would you like to be, with regard to resources, the final outcome where you'd be absolutely 100% happy?
It's a difficult question.
May as well lay it all out now.
But I think from our perspective, it would be a complete redistribution of existing resources into providing proper mental health and addiction supports in particular in the community. And I mean, really, we presented to the high-level task force, and it's difficult for us because we are a penal reform organisation. We're looking at prison, but what we end up talking about prison all the time. But what we really want to try and say is people should never get to the stage where they end up in prison, because so many of them do because of circumstances. So if we could put the resources into the communities where we know there are high levels of people, you know, ending up in prison because of poverty and addiction and mental health, which is all related to socioeconomic disadvantage as well. But then all the kind of services in those communities, and also more generally, as I said, in mental health and addiction, to try and kind of address the root causes so that people don't end up in a position where they end up in contact with the criminal justice system in the first place. So I suppose really in kind of magic, you know, a world waving a magic wand, that is kind of where we'd want to end up, I think, and that we are focused on trying to address those issues at the very outset and actually see why people end up committing the offences, and not just always putting our resources into the reaction and the response.
Excellent. Eilionóir or Eilís, do you want to come in there?
No, I think we just fully support that, and really again would like to see the resources in the community for support based on informed consent, and that's what's really critical. Thank you.
I mean, there's no doubt about it. The opening of the new site for the Central Mental Hospital, it is good news, and I'm hopeful that the more modern and spacious facilities there will improve the lives of residents and staff. However, I do note the section of the report where one of the research participants stated that they felt the planned move served as an excuse for not acting to rectify issues. And I hope that the move will provide a fresh start, and that the new Central Mental Hospital will be adequately resourced and will be held accountable in upholding its human rights obligations through a robust combination of independent advocacy services and legal oversight, and familial input and regular inspections from the National Preventative Mechanism once Ireland ratifies OPCAT. So I think that now is the perfect time to start thinking of a programme of reform for Ireland's forensic mental health service, and I want to thank you all sincerely for your work, for your expertise, for your passion in this area, and we'll stay connected from the committee's point of view, and you'll keep us in the loop as to what's happening. I think that's going to be really important going forward. So yes, I will finish just to say thank you all. The meeting is now adjourned. Hope you all have a lovely Christmas. Sine Dí. Thank you very much.